So welcome to the Torch of Progress. This is the speaker series for our high school level course, Progress Studies for Young Scholars. Progress Studies for Young Scholars is a course in the history of technology, an overview of human progress at least in technology and industry. It originally ran over the summer, this past summer, as a summer program, and is now being run this fall as an after-school program or as part of the virtual school of the Academy of Thought and Industry. You can find out more about it at progressstudies.school. I am your host, Jason Crawford. I run the website, The Roots of Progress, which you can find at rootsofprogress.org, where I write about the history of technology and the philosophy of progress. And our guest today is Adam Mossoff, professor at the Scalia Law School at George Mason University, and an expert in patents and intellectual property. He is also the founder of the Center for the Protection of Intellectual Property at George Mason. So welcome, Adam.
Thank you. Thank you, Jason. It's great to be here.
All right. We've got a few people filtering in, but let's just get started because I'm sure we've got a lot to talk about. So we're going to focus most of the discussion today on patents. Let's just begin at the beginning. What are the origin of patents? Where did they come from?
It's a really great question. Yes, in the beginning, there was a person who invented something. So it's a really great question because even the term patent is very historically contingent, and people might wonder, why do we call these things patents? So it starts in feudal England, hundreds of years ago. And the crown exercised its royal prerogative, its powers as the crown, by granting favors to people. And engaging in various economic and other domestic policies to promote the realm. And the legal mechanism that the crown did this through was by writing these very formal letters that were known as letters patent. So, and it was, the reason why they were called letters patent is because at that time, the English legal system followed what's called law French. They had been heavily influenced by the French language through the Norman invasion of 1066. And so in French, the adjective comes after the noun. So patent here was being used as simply as an adjective of open, as an open letter. So you would get a letter from the crown that you could run a mill or start a commercial area, a trading area, or start a business. And the crown used letters patent generally for issuing all sorts of grants of royal privilege. In fact, our property rights in land all start with letters patent as well as grants to various feudal lords that eventually evolves into our property rights system we have today. And so starting in the 16th or 17th century, the crown starts using these letters patent, actually granting them to inventors to advance the economic development of the realm. And this eventually evolves into a more formalized legal process, one not rife with royal discretion and the abuses that the crown would inherently bring to it by rewarding them to court favorites, by restricting it to people like who are inventors and constraining it by statutes and court decisions and things of that sort. And like good Americans, when we saw letters patent, we said, oh, well, this is English, so clearly the word that matters here, the noun is patent, not letter. So this is how we came to be called these things patents. And of course, we Americanized them as well and call them patents, not patents. And the rest is history.
So it's really interesting. I always assumed before I learned the history of this that, oh, well, it must have been that, at one point, inventions were not protected, and then we created patents in order to protect them. Or at one point, property, land was not protected. Then we created property, land rights or property rights in order to protect them. And it seems like it was actually more of a, there at one point, all kinds of stuff could be protected sort of arbitrarily by royal decree. And what we actually did was we carved away some of that royal power and we left certain things, certain protections in place. So talk a little bit about this evolution from patents as just kind of a royal prerogative to patents as a formalized process and ultimately as a right.
Oh, yes.
How did that happen?
Yes, this is excellent. And the historical development is really fascinating. And also it's important to recognize, even before I start talking about the history of patents, that, you always have to think as compared to what. And so it wasn't even true that there weren't protections for inventions before patent systems started to evolve as we now know them, starting in the late 17th and 18th centuries. Before that, people still invented and they protected their inventions, but they did through things like guilds and through what we now call trade secrets. So they kept things secret. And so actually one of the contributions and one of the important aspects of patents is that they disclose the invention. And so it takes things out of secrecy, because this is one of the things that drives further on innovation and more commercial development, is that when you have knowledge out in the public, and even when it's owned, in fact, when it is in fact owned, that's what facilitates people to transact with each other and to trade with it and to develop it further and build upon it, which is what the patent system promotes, as per the authorization of the Constitution, to promote the progress of the useful arts and science. So it's always important to recognize that there are different types of ways you can protect innovations. In fact, different ways you protect all types of creative work. Copyright protects the written words. Marks and trademarks protect what we call corporate goodwill. And I think the important point is the legal system provide the full panoply of protections for the different types of creative endeavors that people are engaging in, because they create different types of assets with different types of values. And the important point is that they get the respective protection they need. And so a lot of people sometimes think about, well, patents aren't necessary for X. And then they conclude from that, ergo, you don't need intellectual property at all. And that's not necessarily the case. It may be exactly true that patents aren't necessary for X, even though you do still need intellectual property protections. And that's why we have things like trademark and trade secrecy and copyright and other types of intellectual property protections. But they all follow this, well, at least copyright and patents did, because trademarks and trade secrets evolved later when we had a more formal legal system in the 19th century, and we weren't living under the royal system in England. But originally, both copyrights and patents, but patents more dramatically arose out of these grants of royal privilege, which were issued entirely at the discretion of the crown. And of course, so they were abused by the crown. And in being issued to court favorites and as ways of garnering political favoritism and nepotism and all of the things that you come to expect with unlimited power being exercised by a monarch. And in fact, the patent system was very much part and parcel of the constitutional struggles in England in the 17th century. In fact, the Statute of Monopolies of 1624, which is the statute which is the first statute that reflects some aspects of what we now think of when we think of patents, was enacted to restrict and restrain the crown in issuing these patents, these letters patent, for willy-nilly purposes. Through the process that starts in England, they soon start to become understood as legal entitlements that are actually construed, interpreted, and enforced by the common law courts. They're even taken out of the prerogative courts. The Privy Council, which was the court that heard all disputes arising from the crown's use of its royal prerogative power, and were put into the common law courts, which adjudicated the common law rights of citizens or subjects in England. But patents were still viewed as grants conferred by the crown in England. And so they still had an aspect of them that was viewed not as a full property right, but as something that really furthered the economic and other regulatory purposes of the realm. And there were still restrictions imposed upon them. Royal grants or privilege from the crown were granted to the individual, the subject. You got a letter to you as an individual from the crown. The letter wasn't to your children and it wasn't to a business partner, it was to you. And if the crown bestowed a gift on you, that wasn't something you could then transfer to someone else, a business partner, or bequeath through a will to your children. So they truly weren't property rights in the kind of classic sense of what we think of a property right as a legal right that secures to you something, a value that you can acquire through inventive labors or create other productive labors, and then use and dispose of as you will, as you choose with other people. And this was part and parcel of the American Revolution, not just generally, but in patent law. A lot of people don't realize that the patent system was part and parcel of the American Revolution, that this radical transformation that Americans undertook in the 1770s and 1780s in reconceptualizing the purpose of government to secure rights, limiting the government to that function, institutionalizing the rule of law, and having all of the actions of the government be constrained and defined by the rule of law through set statutes and court decisions was applied to the patent system. And so taken completely out of the domain of discretionary authority by, well, the executive, who was our analog to the closest analog to the crown. And in fact, there were some people who were saying we should put the power to secure patents, we should put that in the executive branch, because that's where it was in England. It was a power still under the crown. And the framers in the Constitutional Convention of 77 said, no, we're going to make this one of the powers delegated to Congress, because Congress is the representative of the people, and it's the job of Congress to enact the statutes and create the rules to define and protect people's rights of life, liberty, and property, and patents are part and parcel of that. And so, our patent system from the get-go was defined generally as a property rights system, in the same way that we would protect property rights in farms and in other types of goods. And you see that comparison in the early court opinions made often by judges and other legal officials, that patents arise from the same type of productive labors that you see farmers engaging in and other people engaging in when they raise crops and flocks, and that they should be secured in that, and that is the job of the patent system to do that.
Great. I would love to talk in a little bit. I'll get to more. I'd love to hear more about the U.S. patent system and how it differs from Europe. I want to go back to a thing or two that you said. You mentioned that so before patents, there were different ways that people tried to protect their their secrets or their inventions. And you mentioned that one of the ways was through guilds. Can you talk about that? How would the guilds be used to protect?
Yes. So the guilds. One of the functions of guilds, why guilds arose, was in response to the fact that craft knowledge and technology was very valuable, and they understood the problem that if the information is leaked and gets out, then the people who retain that information now have lost the value of the resource, because it's now freely accessible and usable, and it can't be constrained, and it's harder to stop other people from using it. So one of the actual original governing functions of the guild system was to ensure the secrecy and ensure the internal protection of the various technical arts that comprise the skills of the guild members, whether it was in carpentry or whether it was in masonry or something of this sort. And the guild systems protected this, through their own internal rules. Guilds in some countries were formal legal institutions, but more often than not, they were private institutions. They were private associations, and they enforced their rules through private enforcement remedies. We in the law today refer to this obliquely as self-help. Everyone else would refer to this simply as vigilantism or violence. And so if you broke the rule of your guild, you would be usually beaten up, kicked out of the guild, and sometimes killed. And because that was the only way that they could enforce the secrecy. They recognized after several hundred years, as part of the Enlightenment, as part of the development of the Enlightenment, that creating other alternative legal mechanisms for protecting the fruits of inventive and creative labors, while at the same time distributing knowledge in a more peaceful and economically efficient and productive manner, would be good for everyone, would lead to flourishing lives and flourishing societies. And that was in part and parcel some of the impetus for thinking about taking this existing device that the Crown was using for personal purposes, or at least the rationalization for the letters patent for inventions and technologies was that this was just an economic policy, just domestic policy development of the realm. grant someone a monopoly so that they'll develop the technology. They start to think about, well, we have this kind of semi-existing legal mechanism. We can convert it into something that actually will serve other purposes and better purposes, both for individuals and society at large.
So if I'm a blacksmith, let's say, and I, in the whatever 1500s maybe, I am part of the Blacksmiths Guild. Suppose I devise or somehow come up with a better way to make steel, and I can make now tougher steel, better swords. So one thing I can do is I can keep that a secret. Don't tell anybody how I do it, and now I can command a higher price for my wares, presumably because they're higher quality. Is there another option? So through the guild, is there some, if I tell the guild, maybe we'll keep it a secret within the guild, but all my fellow blacksmiths now benefit from my discovery. Is there a way to get, was there a way within the guild system to get kind of paid for that, even by your fellow blacksmiths, or like, could you get a reward?
I don't know. I must confess, I don't know all of the intricate details of the different ways in which the guilds functioned and how they worked. I know them only generally as an institutional alternative to systems like patent systems and copyright systems and trademark systems. Because if you don't provide, the point is that humans will create the institutions and other mechanisms, both formal and informal, to protect information or protect the values that they're creating. If you don't provide the type of protection that should be provided to them. And so it's an advance, and more importantly, as you said, like, regardless of whether you shared it with the guild or not, the point is it was still kept secret, whether it was kept secret to you or it was kept secret to the guild. And in fact, this is probably why a lot, the development of technology and innovations was largely flat for a very long time, in addition to many other social, economic, and technological factors, is because people were human beings, we're naturally creative, we think about things, but new information and new ways of doing things died with people because they either kept it secret to themselves or it was kept secret to the guild. And the guilds weren't designed to promote innovation. Guilds were designed to keep information internal to them only. So the guild didn't have any incentive to try to build on top of any new information either. If someone happened to do that and the guild developed it, then that happened. But that wasn't part and parcel what happens. It's really significant that, patents, and this is one of the reasons why you sometimes hear, well, patents are a blockade, they stop people from innovating. It's like, actually, patents are the exact opposite. It's one of the reasons why patent lawyers sometimes scratch their heads at that framing of patents and in the policy debates or by people more generally. It's more rhetoric than reality, because the whole purpose of one of the functions of patents is to publish the knowledge. Patents are published; they're made public. Anyone can read them, and anyone can build off of them and invent on top of those inventions. And in fact, that's one of the reasons why patents are published. So one of the reasons is so that people can innovate on top of it. And then if you create an innovation on top of a prior innovation, then you enter into what's called a license agreement. You go back to the original inventor and say, well, I need to use your invention in my invention. It's in your interest because you're going to make more money. And this person says, awesome. And and therefore you enter into a contract that we call in intellectual property circles a license. And I'm not being bombastic. I mean, trillions of dollars exchange hands every year through intellectual property transactions like that maximize value, that further spur innovative developments and actually convert inventions that occur in labs and in garages actually into usable technologies by consumers that's sold in the marketplace.
What about, were there other, you mentioned about sort of the history of England, were there other precursors to patents or anything? I've heard some things about perhaps maybe 15th century Venice, kind of Renaissance Italy, like around there. Where else in history do we see any kind of precursors to patents?
So the earliest that you see to what we now have as patents, the modern patent system, which really doesn't develop until as I mentioned, until the 18th century. In fact, the American patent system became the model that the rest of the world copied in the 19th century, in part because of the success of America. The patent system was part and parcel of the tremendous economic growth in this country in the 19th century. And so, but the earliest precursor to that you see that's closer to that is Venice. Venice enacted a statute that was something like a patent. It provided some protection for an invention, legal protection that was term limited, but it was not what we now know as patents. It had elements of what we now think of as patents. So it had superficial similarities, but it really did. But what we now identify as patent systems are relatively new, just like most property rights and most kind of other types of legal and corporate rights that we have are relatively new. So this is another common complaint that people have. Oh, well, patents are very new. They're just a couple hundred years old. This is what makes them suspicious, or compared to property rights and land. It's like, well, property rights and land only evolved several hundred years before patents did. I mean, in the grand scheme of human history, they're both pretty new. I mean, property rights and land as we now know it, in fact, the modern property right and land, what lawyers call a fee simple, again, law French, it would be a simple fee with the adjective coming after, really doesn't come into existence as we know until about the 17th century. So these are all relatively modern developments that went hand in hand with kind of the Enlightenment, the scientific revolution, and very importantly, the philosophical revolution that was part and parcel of the Enlightenment in the 17th century that you saw with philosophers like John Locke, and that spread through political institutions and created the foundations for, of course, the framers in this country, the founders who created the United States of America.
So let's talk more about that. The U.S. patent system. What else was sort of new or special about it? What was different from the European system?
So, the U.S. patent system. Let me step back. All right. So the reason why we have a patent system in this country is because it's in the Constitution. It's in Article 1, Section 8, which is the section of the Constitution where all the powers that are delegated to Congress are listed. So along with authorizing Congress to create an army and a navy, to create a post office, to enter into treaties with the Indian tribes and other foreign nations, Congress is authorized to create a patent and copyright system. It's authorized to promote the progress of science and useful arts by securing to inventors and authors an exclusive right in their discoveries and writings. And the framers took this very seriously. Some of the very first legislation enacted by the first Congress in 1790 was the Patent Act of 1790 and the Copyright Act of 1790. I mean, and to put this into context, this is a time period in the 1790 when Congress was spent months debating about how they were going to refer to President Washington. Were they going to refer to him as His Excellency or Your Presidency or Your Honor? I mean, this is when they were still debating, and it took years to resolve where were they going to put the capital, whether it's, is it going to stay in New York, is it going to go to, where Philadelphia, where is it going to go? They immediately enacted a copyright and patent statute. They understood that this was foundational to protecting the rights of innovators and creators, and that it was important for the growth of our country and the flourishing society that we would become. And in fact, it bears noting that it's just an interesting point to make as well. The Patent and Copyright Clause in Article 1, Section 8, and it's Clause 8 in Article 1, Section 8, is the only place in the Constitution proper. So the Constitution written at the Constitutional Convention of 1787, where you find the word right even used, where Congress is authorized to secure the exclusive right to inventors and authors, their discoveries and writings. So pre-Bill of Rights, the document only has one place where it mentions the word right, and that's in the Copyright and Patent Clause, or Patent and Copyright Clause. They're synonyms. And so it again shows you the seriousness in which they took this. The fact that they put it in Congress, as I mentioned, took it away from the executive, which was the English model, that it was primarily in the executive branch, and it was part and parcel of the Crown's powers. That they recognized this as a right, and that they recognized this as something that was going to be secured through statutes that would be defined through institutions governed by the rule of law. So Congress enacting the statutes, but also they created initially a review board that had that was staffed by various cabinet members. Thomas Jefferson was one of the people initially as a Secretary of State who reviewed patent applications. They very quickly recognized they needed to create a separate agency for this, so they created the Patent Office. And in fact, the Patent Office was the very first federal agency ever created in our government. But it was defined by the rule of law, governed by the statutes that dictated to the Patent Office how would you review patent applications. And we also broke from, so these were all ways in which we broke from England. Because in England, patents, as I mentioned, there were some statutes that governed it, and they were being adjudicated, as we say in the law. These disputes were being resolved over patents in courts of law, but they were still being issued by the Crown, and it was still being viewed very much in this context of a privilege being issued by the Crown. So it was not a property right in the full sense of the term. So unless the privilege grant says you could transfer it to someone, the default presumption, the default rules we say in the law was that you couldn't transfer it because it was a grant to you directly by the Crown. Whereas in the United States, we took the exact opposite approach. We said the default rule is that a patent is a property right. And so from the get-go, it's transferable in the marketplace. You can do whatever you want with it, just like a farmer can sell their corn to a wholesaler directly to consumers. They can sell 1 year, they can sell 10 years, they can sell future rights in their corn, they can use their corn as collateral. These are all the ways in which property serves as a foundation for people to engage in innovative commercial transactions in the marketplace, to grow our lives, to benefit ourselves individually and to grow the economy. And so we from the get-go said patents should serve the same function that property rights in farms and in mills and in other types of assets should serve. And so inventors immediately did that. And so the inventors in the United States immediately exemplified the principle identified by Adam Smith in The Wealth of Nations in 1776 when it was published, which is specialization and division of labor. That, inventors said, well, I can invent, but that doesn't mean I have to be a manufacturer. And I don't have to be the wholesaler and also the retailer. I don't have to do everything. We can trade with each other and specialize and exploit our respective capabilities and specialization and maximize value through trade and through division of labor exchanges in what's now called the value chain in manufacturing and production. And so very early on, there was an active market in the trading and selling of patents in the United States. And inventors embraced this division of labor. So people like Charles Goodyear, the inventor of the process for making vulcanized rubber. A lot of people think Goodyear actually made rubber because of the Goodyear Tire and Rubber Company. But Goodyear had nothing to do with the Goodyear Tire and Rubber Company. The company was formed 40 years after he died. He didn't manufacture rubber. He licensed and transferred his patent rights to other people to do it. Elias Howe, the inventor of the lock stitch and the sewing machine, he just licensed his rights to other people. Thomas Edison and Nikola Tesla and all of these people. Nikola Tesla, his business model has been characterized as promote, patent, and sell, meaning promote your invention, get a patent on it, and then sell the patent to someone who will manufacture it. So so this is this helped further the early economic growth of our country because innovators weren't forced to spend time figuring out how to manufacture and figure out how to transfer and sell. And they didn't have to become the sole person that did everything. They could embrace the division of labor. There's a key difference between the US and England that's been identified by many historians and economists. Now, England eventually realized, oh yeah, like our patents are going to be more valuable if we allow them to be transferable in the marketplace, like other property rights. So they started putting into the patent grants, well, you can transfer this or sell this in the marketplace if you wish. But that had to be expressly provided for. That wasn't the assumption in the nature of the legal grant. And so there was an understanding, well, the Crown could always take it back. In fact, that was the rule in England. It was called the Crown's right or the Crown's privilege. Because it was viewed as a grant from the government, from the Crown, then the idea was what the Crown giveth, the Crown can taketh away. And so the Crown always had a claim to use a patent for whatever purpose or reason that it wanted to do so. Without having to pay and without having to get authorization from the patent owner. In the United States, we took the exact opposite approach. We said, no, these are property rights, like property rights in farms, and the government can't just take your farm. And if they do take your farm, then there's constitutional provisions and law that governs how and why the government can do that. known as the Takings Clause in the Fifth Amendment, right? So the government can only do it under limited conditions, and it has to pay you. And in fact, it's in some of the takings cases in the 19th century that you get some of the more stronger statements about US patents as being property rights, and where the courts explicitly distinguish them against English patents on these terms. That, here we follow the rule of law and we respect the property rights of innovators and inventors in ways that they don't in England and the rest of the continent. England wasn't unique in this. This was standard practice in the rest of the continent. And this was largely true for most of the 19th century, up and through even the 20th century. Other countries often claimed what we now call in patent law compulsory licensing, the power to take a patent and use it or sell it however they wish, because it came from the government and they said we could just take it away. And so what you see is the United States was creating in its patent system the same types of institutions, the same types of doctrines, the same types of rules that it was creating in for American citizens in all other areas of their life, whether they were creating factories, whether they were building out their farms, whether they were creating banks and other types of institutions. In all those contexts, they had the rule of law, and they had the guarantee of the backstop of due process protections, of constitutional protections, and the understanding that if we have disputes, they will be resolved by neutral arbitrators and courts through set rules, through due process, and substantive protection of our rights of life, liberty, and property. And patent owners were able to rely upon that as a base assumption. And that's why they were able to that's why they were freed then, and to just invent and create. And this is why, as I mentioned, Elias Howe and Charles Goodyear, but Samuel Morse, the inventor of the electromagnetic telegraph, and Samuel Colt, the inventor of the repeating firearm, and Cyrus McCormick, the inventor of the mechanized reaper, and Woolworth, the inventor of the first plane machine for making wood, standardized wood and leather products. This was all invented and created in the United States in the first 30 or 40 years of the 19th century. And it was a marvel to the rest of the world. And it's what was part and parcel of what was driving our just massive explosive innovation economy at that time. The Industrial Revolution that we now call it. Sorry, I'm going on because it's such a cool story about.
Yeah, absolutely.
It involves so many different elements, and of which the patent system was part. It's not all reducible to the patent system, because you have to have the rule of law. You have to have, the protection of life, liberty, and property. You have to have settled, institutions, legal institutions that people can rely upon. You have to have general freedom in society. It's not like you can build a patent system and that's all you need. That's what China's trying to do right now, and it'll be interesting to see what happens there. They think we have a good patent system. That's all we need. We don't need rule of law. We can be still a tyranny. No, that's not true. And so, but definitely the patent system was very much part and parcel of what historians refer to as American exceptionalism, and what's part and parcel of the unique American experience of the 19th century.
Yeah. Wow. Great. So let's see. We're going to go to audience questions in maybe 5 or 10 minutes. So if anybody has questions for Professor Mossoff, go ahead and just put them in the chat. If we for students of the course, as always, we have the thread in our private Slack, and I'll try to give priority to your questions. But everybody else, just go ahead and kind of type them into the chat in the Zoom here, the Zoom chat, and then we'll get to them in maybe 10 minutes or so.
Okay.
Okay, great. So I promised in promoting this that we would talk about quote unquote patent trolls. Yeah. So let's talk about that. So what does that term even mean? Why do people use it? It's obviously a very negative term. And then, is there another way to look at this? Like, do these so-called trolls have an actual, valuable function?
Yes. Of course, no. Oh, of course, no. Calling someone a troll is totally positive. Like they're cute and furry. Yeah. So clearly, it's a pejorative term that has arisen in the patent policy debates in the past. It's a relatively new term. It really started to come into vogue about 15 years ago. And I don't like the term, and I don't use it. the reason is for the same reason I don't use the term robber baron, is that it's a pejorative term that's used in the policy debates by people who have either by academics and other scholars and activists and commentators who are very critical of the patent system, or by companies who have a vested interest in given their current business models and weakening patents because this assists them in their current business models, and so they're pushing this patent troll term. But the reason why I don't use it, as I mentioned, is it has the same status as robber baron. It's, as you mentioned, it's pejorative, and it has no settled definition or meaning. And so it's not objective in the sense. The generalized framing of the term, to the extent that there is a meaning to it, is anyone who doesn't manufacture their patented invention, right? But as I just described, right, then that means Charles Goodyear was a patent troll, and Elias Howe was a patent troll, and Thomas Edison, and Nikola Tesla, because these people didn't manufacture their inventions. They licensed and sold and engaged in lawsuits with people who infringed their patent rights. And so when you posit that to them, they say, oh, well, no, we don't mean them. So we mean someone who has a bad patent. And he's like, well, what do you mean by a bad patent? What's a bad patent? Is that like living on the wrong side of the patent tracks? Is it being a bad person? Oh no, low quality patent. Somebody takes a low, well, what do you mean by that? Because there's no historical or subtle baseline for defining what counts as a quality patent. There's no economic or statistical study that has shown that we have more so-called low-quality patents or bad patents issuing today than we did 20 years ago, 30 years ago, 40 years ago, or even 100 years ago. I mean, we couldn't have those studies, even if we wanted to try to create them, because the technology has changed, right? So what makes potentially a advanced biotech innovation today a good quality patent or a low quality patent has nothing in common with Westinghouse's invention on the steam brake for railroads. And so if you hear claims like, well, the patent office is issuing lots of bad patents today, one of the questions asked is, well, how do we know that? I mean, people say that, but I mean, people say there were lots of bad robber barons in the 19th century. How do we know that? People say that. Now, are there some bad actors in the patent system? Are there some people who are there some mistakenly issued patents? Of course. I mean, no human institution is going to meet some platonic ideal of perfection. Humans are not omniscient, and so we make mistakes, and the patent office issues them, and we often hear of the mistakes. Like, there were a patent issued on a method of using a laser pointer to exercise a cat, and a patent on a method of using a tree swing. I mean, the patent office also issues more than 300,000 patents a year. And so then the question becomes, well, are there more of these types of patents issuing now compared to 100 years ago? In 1820, we were issuing, I think there were 25, I think there were, several hundred patents issued by the U.S. Patent Trademark Office. I don't recall the exact number. I mean, how many of those were bad patents? We don't know. I mean, no one has done these studies because they can't, because also the legal standards were different back then. Technology was different back then. And just, you're comparing apples to oranges, both legally and technologically. And so the problem here is you have a lot of rhetoric, but no real actual underlying fact-based, evidence-based discourse occurring when you have people talking about patent trolls. And unfortunately, as I mentioned, the term though is used by people who are very skeptical of patents or have problems with patent system more generally, or by companies who unfortunately pragmatically have taken a position against patents. And they're not making these distinctions. They're attacking the patent system more generally with this term. In the same way that people who complain about robber barons aren't, saying, well, I'm just using this term in a very narrow, limited sense. If someone says to you, well, there were the problem with the robber barons in the 19th century, usually what they mean is, well, capitalists are out of control and they need to be restrained or restricted in some way, shape, or form. It's generally a critical term of capitalism. And patent troll has become a generally critical term of innovators, where they highlight some of the bad examples of some bad actors, which exist in all areas of law. I teach regular property cases where people abuse their property rights in land vis-a-vis their neighbors. We don't then say, well, there's the problem of land trolls. Or let me give another example. I support patent trolls in the same way that I support, I'm supportive of developers. Developers have a horrible reputation in our country. I myself had a very bad experience with a real estate developer who cost me, when I purchased my first condo, about $10,000. Well, I haven't turned around and say, well, developers are horrible as a whole class of people, and there's a whole category of bad. I mean, I dealt with one bad person, and it's important. It cost me some money, a lot of money back then, because I was broke and massively in debt as a law student. But I still recognize that developers as a whole, that's a good institution we have in society. It's a good, that is a productive, value enhancing activity for people to engage in, and it's a legitimate use of their property rights. Because what patent troll rhetoric leads people to do is, because the general framing is it's someone who doesn't manufacture. Anyone then who doesn't manufacture their patent ends up getting swept up in these condemnations. And so, for instance, one often hears, there's a very famous study. I shouldn't say one often hears. It's a very famous study. One often hears it within DC in the patent policy debates. Oh, patent trolls cost the US economy $29 billion in costs in 2011. Well, first of all, it was a really bad, horrible study that failed lots of just basic requirements for doing statistical studies. But you don't even have to get into those details. Their definition of a patent troll included anyone who didn't manufacture a patent. So who counted as a patent troll, according to Mike Moyer and Jim Besson, the authors of the study? Universities, because universities don't manufacture their patents, they license their patents. Inventors, like Elias Howe and Charles Goodyear, who don't manufacture, who license. Companies that only license, and there are tons of companies who engage in licensing as their business model. Qualcomm and now Nokia, which used to make phones but doesn't. Licensing is just commercial exchange. I have a particular technology. I want to be part of the value chain, in the production of a particular product. I can contribute something. I'll license you to make this aspect of it. And also the definition included companies that were manufacturing companies that happen to own patents, that license those patents outside of their field, outside of their specific licensing or manufacturing practice, which happens all the time. Companies have R&D departments, they come up with interesting inventions, and they say, oh, okay, we'll license this to other people. A good example of this, a lot of people don't know this, Microsoft, for about 10 years, made over $1 billion a year annually in revenue on licensing patents that it had that covered the Android operating system. And Microsoft didn't make Android smartphones. It didn't sell Android smartphones. It tried selling its own failed Windows phone for a while. So, and that got, by the definition of those authors, Microsoft was a patent troll. And so you can see the term it's not an appropriate objective term. We shouldn't be using it for the same reasons we don't use robber baron and other types of kind of terms that are used non-objectively for rhetorical purposes that aren't rooted in real kind of solid evidence-based knowledge that we derive from actual situations in the real world.
All right, we do have a handful of audience questions now. Before we go to them, I want to ask one last question that I've been asking to a bunch of speakers. Now, this is especially for the high school students and the teenagers in our audience. What is a piece of advice that is commonly given to teenagers that you think is actually wrong, and what would you replace it with?
That's a really great question. What's a piece of advice that's commonly given to teenagers that you think is wrong? That's a really great question, because I don't, and I had to think for a moment because I don't interact with teenagers a lot. I teach graduate students, so, but I'll have some. I have a teenager myself now, so so this is good that I start thinking about these things. I think one of the a very common piece of advice I think that one often hears, or it's not explicitly made, but it's often implicit, is, well, what do you want to do with your life? You have to figure out as a teenager, like what your career is going to be, what your passion is. And you can't as a teenager. You can't really even as a young adult. You can't know what you love and what really drives you until you do it, until you actually engage with the world and undertake some experiences, or at least start to study these issues, And so don't worry too much about like figuring out like, oh, what am I going to be doing with my life? And am I going to be an entrepreneur and do a startup, or am I going to be going to finance? You may like that, and so pursue it if you think you might like it, but also be willing to recognize, once you start doing it, you may discover, actually, no, there's something here about this that I really don't like it, and I need to change. And you should be willing to do that, because you can't deduce abstractly. You're not born with a set of values that drive you and inspire you to produce the best work and to wake up every day and say, I am loving my work and loving my life and ready to go. And the only way you discover that value is by taking action in the real world to pursue it and seeing how it feels to you and whether it's something that really means something to you. And I'm speaking probably from personal experience. I changed my focus in terms of my career goals 3 or 4 times. When I first went to college, I thought I grew up in the 80s, so I was gonna go to Wall Street and become a millionaire by the time I'm 30. And so I was getting a degree in economics and international affairs. And then I realized, oh no, I don't wanna do that. And then I started to get interested in legal philosophy. I took a legal philosophy course. I always loved philosophy. And it wasn't until I took a legal philosophy course that I was like, wow, this is really exciting. This is really cool. So this is what I'll do. I'll do legal philosophy. So I'll be a philosopher specializing in legal philosophy. So I'm going to go into academia. And I pursued that for a very long time, actually. I got a degree in philosophy, and then I went to a PhD program in philosophy, and I was in that for 5.5 years before I realized, I hate this. I hate being in academic philosophy. I'm a slow learner, but I figured it out. And of course, one of the reasons why I figured this out was because I started taking courses in graduate school, in the law school, where I was in graduate school at Columbia. And I was really enjoying my law professors, and I was really enjoying my interactions with the law students. And I really was not enjoying my philosophy professors or my interactions with the philosophy student and my fellow graduate students, and a lot of the philosophy students as well. And I realized I'm on the wrong side of the academic divide. I want to be a law professor. And so I switched in the late 90s. I was always planning on going to law school to back up my PhD in philosophy. I left a PhD program. I didn't get a PhD. But I never looked back, and I love what I do. And you just have to be open to realizing and being very sensitive to, well, you thought you might like this, but you don't, and that's okay, because that's part and parcel of the learning process. In fact, as a parent, I can tell you the way we learn is by making mistakes, by trying something and not liking it, or making a mistake, and then you now know what you don't like, and that tells you what you do like, or what's the right way to do something.
Cool, that's a great story, and echoes a little bit, I think, some of the answers we've heard from previous speakers, actually, in terms of maybe take a little bit longer. Don't be in a rush to figure out, what you want to commit like the rest of your life to.
Yeah.
Okay, great. So we've got some questions from the audience now. So let's go to these. There is a story that in the late 1800s, somebody who was running the patent office, I think, said that the patent office is going to need to shut down soon because there was nothing left to invent. Is this true? Do you know, is there a source from this, or is this a urban legend?
It's one of these half truths. It's like, yes, someone said something like that, but not literally. So there was someone in the patent office who said along the lines of like, everything is starting, our impression is everything is starting to be invented. But he wasn't advocating for, it was an off the cuff remark, and he wasn't advocating for shutting down the patent office. He didn't advocate for that. It's how it's characterized, like, oh, the hubris of people, they didn't realize that, because the more inventions would be created, because they knew that. They lived through it at the patent office. And in fact, the late 19th century is right around the time where we finally, the scientists finally figure out in the space of chemistry, right? They finally figure out and settle on the periodic table of elements. As the agreed upon model, and it becomes accepted scientific knowledge that the atomic model of matter, and so you're just on the cusp now of the pharmaceutical revolution, because now they understand exactly how molecules work, and so right around this time you start getting some of the very early first true, real, valuable pharmaceutical patents that start to issue around the turn of the 20th century. And and the U.S. is the birthplace for this, and we, because we provided solid protection for these new types of innovations, from pharmaceuticals all the way up through computers. We also led the world in protecting computers as well, providing patent protections.
That's interesting. I thought a lot of the early pharmaceuticals came out of Germany, right? Bayer, Hext, BASF, these German chemical companies.
Yes, pharmaceutical inventions and patents, and they were getting patents on them as well in Germany. But the U.S. overtakes Germany very soon. And I shouldn't say very soon. In the 20th century, the U.S. overtakes Germany. So by the time you get to the mid 20th century, a lot of the primary pharmaceutical innovations are occurring in the United States. And then, very significantly, there's a very famous 1980 Supreme Court decision called Diamond v Chakrabarty, where the U.S. Supreme Court says that a genetically modified organism, in this case was a bacteria that had been genetically modified to eat oil. It didn't work, but it had been genetically modified. It was a patentable invention. The Patent Office originally said no, it wasn't, because this is just a natural phenomenon. It's a living animal. And Chakrabarty, who was a very famous medical researcher, took it all the way to the U.S. Supreme Court. The Supreme Court said, yeah, no, this is an invention. This is a valuable creation. This is exactly what the patent system is designed to promote and secure. And the U.S. was unique in this, because other countries said, no, we are not allowing patenting on life. We're not allowing patenting on these types of early biotech innovations. And the United States stood out from that and said, no, we are. And it's the reason why the biotech revolution happens in the United States, because immediately as a result of the U.S. Supreme Court and then issuing this decision as an interpretation of the patent laws, and then the Patent Office saying, okay, we're open for business. Please submit your patent applications. Venture capital started flowing just by leaps and bounds to biomedical researchers. And this is universally recognized as one of the reasons why the biomedical revolution occurs in the United States in the 1980s and 1990s, is because we were the first country compared to the rest of the world to provide protections in this space.
Wow. Okay, next question. Harry Mullen says he hears the U.S. patent system has declined and other countries have better ones. So is that true? Do you agree? And if so, can you summarize the issues?
Yes, so yes, you've probably heard that from me. Because I've been writing on this and speaking on this in op-eds and in my academic work and scholarship, and these are some of the issues I've testified before Congress on. So in the past 10 or 15 years, part and parcel of actually the patent troll policy narrative that has really overtaken has overtaken Congress and the courts and the regulatory agencies. There's been a moral panic about the patent system in Washington, D.C. People think, oh yeah, patent trolls are running rampant and the patent system's broken and innovators can't innovate and everything. And so Congress has constantly been amending the laws, the patent system laws, to weaken patent rights, to make it harder to get patents, harder to license them, harder to enforce them. The U.S. Supreme Court has been issuing decisions in patent cases at a greater rate than we have seen in almost 100 years. And most of these decisions weaken, eliminate, or outright just eviscerate patent rights, the ability of innovators to get their patents. So I mentioned the biotech revolution occurring because they said you can get a patent on a biotech innovation. Well, under recent U.S. Supreme Court decisions in the past 8 years, that's now in doubt. And now people who get patents on incredible biotech innovations that treat hepatitis and diabetes and cancer, the same invention. Patents on these inventions are now issuing in Europe and are even issuing in China. But the U.S. Patent Office is denying patents on these inventions. It's been very hard to, as a result of the patent troll narrative, that there's all these bad patents and bad actors, so we should reduce the ability of patent owners to get their legitimate legal remedies for when people violate their rights. You can get damages, and so the value of damages has been reduced significantly. What a court will give you as damages, and your ability to get an injunction has been severely hampered as well. And we've created a whole administrative tribunal at the Patent Office called the Patent Trial and Appeal Board, goes by the acronym PTAB, whose sole job is to cancel patents, issue patents, and anyone can file a petition from anywhere in the world for any reason to cancel a patent. the PTAT has cancellation rates that have ranged over the past. It was created in 2011 and started hearing cases in 2012. From 2012 to today, cancellation rates have ranged anywhere from 70% to as much as 100%. And so this has severely devalued patents because in the United States, US patent rights have become unreliable and they're not become effective. They've not become a property right that you can point to and say, venture capitalist or other company that I want to license with, you can depend on this as a valid, stable property right that we can transact over. Or I can use this as collateral to get venture capital funding. And venture capital funding is drying up, as studies are showing, in patent-intensive industries. So in the biotech industry, biopharmaceutical industry, medical device industry, and even in some of the patent-intensive areas of the high-tech economy and the computer industry, you have venture capital shifting away from those areas because they're less reliable investments. And this is very significant because, as I mentioned, China has developed the exact opposite in the past 5 or 6 years, which is, no one foresaw that China would develop a very robust and stable patent system. And Europe continues to generally protect patents as well as they have after they modeled themselves after the US in the 20th century. So in a certain sense, we are in the process of going back to what patents were like under the royal prerogative power, where they're administered through discretionary processes in the administrative state that aren't function under the rule of law, where there's a lot of uncertainty and lack of protection and recognition for due process, and lack of core property right protections, throwing off all of the elements of the patent system that made it so successful in the United States. And other countries are going the opposite direction. And we live in a global economy. And so venture capital and economic growth will flow to the places where you have stable property rights protections and you have the ability to ground economic activity and the foundation of property rights. So it's a real concern. And the problem with the patent system is that you don't see the harm from weakening our patent system isn't tomorrow. It's 10 years from now. Or for modern biopharmaceutical companies, their timeline of investment is 15 to 20 years. So the problem is, it won't be until later in the 2020s that we see the byproducts of this. And by then, no one will connect it with what happened 20 to 30 years earlier with the weakening of our patent system, unfortunately.
Yeah, wow. Okay, great. We've got just a couple of minutes left, so I'm gonna skip around and see if we can get maybe 1 or 2 more questions in. Tom Gilb mentions that his father had 100 patents, but said that patents don't give real industrial protection because it's too easy for someone to patent a small variation. And therefore your real protection is fast deployment. What do you think about this?
So it depends. So yes and no. I mean, so yeah, you can, and I would have to understand what the patents are because in some contexts it's not true, in other contexts it is. So pioneering patents, foundational patents, there are no variations. So Alexander Graham Bell, when he invented the telephone, I mean, he had total control over the entire telephone industry because there was no other way to operate telephones other than by modulating the frequency of the sound waves. And so if you're talking about like you yourself are engaging in incremental innovations, they're published, people can read the patents, and then they can do something called designing around, which they can make competing products in the marketplace that are distinct from and separate from, but nonetheless they themselves can get a patent on it as well. Then that's what happens in the marketplace, right? This is part and parcel of what property rights promote and secure. You create a school that's really successful. Someone can look at what you did and say, that's a really successful school. I want to create a successful school too. I'm going to model it after yours, right? I'm going to copy it. And this happens, right? First there was Coke, then there was Pepsi, and then there was Tab, and then there was other generic sodas, right? So it's a little, it depends on what you mean by the particular types of technology and the particular types of invention and the different types of business models and the particular sector of the economy which you're working with. And in fact, where you have inventions or an innovative work where you don't have large scale R&D that's necessary to produce a product, and there's fast development of the products and processes, typically patents are not relied on as business models in those contexts. They rely on other types of IP interests like trademark and even copyright. Because that accommodates the different types of economic activity that you're engaging in this space. And this is the important point to recognize. Patents aren't the be-all or end-all. They function as property rights for a certain type of value someone creates with a certain type of business model and a certain type of sector of the economy. And for other types of business models and other types of sectors of the economy and other types of values, you want other types of IP rights. And the important point is to have all of them there for the different types of innovative and creative labors that people are engaging in.
Great. Okay, let's sneak in maybe one last really quick one, hopefully. Book recommendations about the history of patents. What do you recommend?
So, there are not a lot of really kind of just general audience, lay audience books that have been written about patents. There are some really interesting like history books, like the book by Zarina Khan, The Democratization of Invention, which highlights some of these aspects of the historical differences between the U.S. and other countries that I talked about. But that's published by Cambridge University Press. It's an academic book. Something that I do because I love what I do is I read books on inventors and innovators all the time. And almost all biographies of the great inventors and innovators have sometimes whole chapters, if not multiple chapters, on the patent system in there, because they engage with the patent system. Goodyear did, and Thomas Edison did, and Isaac Singer did, and Samuel Colt did, and Samuel Morse did. And so, really, what I would recommend, and I have lists on the internet in various places, and I can share generally with Jason, is I listed just cool books on the development of the history of technology and innovation. But there is one book that I would recommend, and that is the most powerful idea in the world. And I'm blanking on the author's name. Jason, I see you.
Rosen, William Rosen. Yeah.
It's an excellent book that melds the history of science, technology, politics, and patents. And I think it tells a very compelling and interesting historical story of the evolution of the patent system in England in 17th and 18th centuries. And he's right about England compared to other countries, of how England had a better patent system compared to other countries. And then we did it even better. I'm happy to answer more questions if people would like to stay.
Okay, yeah, sure. Let's just take just a couple minutes, and obviously, if anybody has to go, you go ahead. But maybe we can get in one or two last questions. So let's see. So Trey Knighton asks a question about whether patents are more or less important today versus, say, 40 years ago. He points out that in the age of information and telecom, there's a much larger customer base for new inventions, but also more people can copy an invention. R&D is a higher percentage of costs. He suggests that more of what consumers consume is non-rival. So how does this contribute to patents being more or less important?
So it's a really great question, because one of the really cool things about patents, and one of the reasons why I wanted to do patent law, is because patents are about protecting new innovations on the cutting edge of human knowledge, of technology, and of business. Because a lot of patent owners also innovated commercial enterprises and business models. So, like for instance, Isaac Singer invented the sale-leaseback model, and Samuel Morse and many others innovated the franchise business model through licensing of their patents and other IP interests. And I can tell you, when you read the history of these individuals and what they were doing, people were saying the exact same thing then. And because if you could think about it, right, in the early 19th century, right, when we now had, transmitting information by electricity. So up until that time, for all of human history, information only was transferred at the speed of horse or sail boats, right? And now you could actually send a message across the ocean by the 1860s. That took just a matter of minutes, right? You had massive commercial enterprises that existed in the 19th century that didn't exist 50 years before. Singer Sewing Machine Company was the first multinational corporation in the United States. They were selling more sewing machines in Europe in the 1860s than they were in the United States. In fact, the largest factory in the United States in the 1870s was a Singer sewing machine factory in New Jersey. I mean, so at every point in time, right, you have all of this new commercial activity, new creation of commerce, of customer bases, new methods of making money, new business models. We now know the internet. The internet is another massive revolution of the type that we went through with the Industrial Revolution. And so you have to be careful not to be too tied to the particular unique aspects of your particular era, because when you think about it, every era has been unique compared to the era that came before it in terms of speed of transmission of information, the technological base, the ability which people can make and innovate money, and other types of activities in our society. But you do hear very oftentimes, especially in the context of the high-tech industry or a portion of the high-tech industry, the Silicon Valley portion, the internet-based portion, like, well, patents are this outmoded mode of protecting innovation because we don't really need it now. We have other methods of making business. Well, that's not true for all the high-tech industry or all innovations today. In fact, there is even in the high-tech industry, there are many inventions in the high-tech industry that require hundreds of millions, if not billions of dollars to create through R&D. One example is the digital transmission technology in your smartphone, the 4G, 5G. 5G took Qualcomm about 12 years and billions of dollars to invent. And they need patents. They need patents to secure to them the fruits of their labors, their productive labors over all of that time, to license now the technology, because they don't manufacture anything. They license the technology that they invented, the 5G, 4G, 3G, to companies like Samsung and Apple and other companies that make smartphones. Also companies that make, enterprise software systems, invest lots of money to create these types of innovations. The average cost of a single drug, the average cost of R&D that is represented by a single drug that is approved by the FDA to be sold to patients in the healthcare market is $2.6 billion in R&D expenditures. Not behind that one single drug, because that one single drug represents about 10,000 molecules that the pharmaceutical company originally started researching and were dry wells. They didn't lead to anything. And then it represents all the testing that they have to do and the development of the mechanisms for delivering it into your body, which are all innovative as well. It takes about 2.6 billion total in R&D, sunk cost, and 10 to 12 years on average to come up with a successful therapeutic drug treatment that's sold in the healthcare market. And even out of that, then only one out of 4 of those actually makes enough money to pay that back and pay for the ongoing R&D that they're doing. So it's not true even in the generally, because there's still lots of industries that require patents for these types of significant upfront ex-ante R&D expenditures and licensing business models. But it's not even necessarily true in the high-tech industry. Now, in the portions of the industry where it is, they don't rely upon patents. So social media companies, certain internet type companies, they have business models that don't rely upon patents. If you're an app developer, you don't need patents, right? It doesn't take $2.6 billion to create the Flappy Bird app, right? So, and that's a good thing. That's why we get the Flappy Bird app, right? But they rely on other intellectual property, right? So very, very famously, the creator whose name I'm blanking on at the moment of Angry Birds, the Angry Birds app, famously, I don't need intellectual property because I didn't need it to create Angry Birds, which was true. Right? But what he meant by intellectual property was patents. Because when people started copying Angry Birds, boy, did he start suing a lot of people for trademark infringement. So what he was relying upon was the protection of the corporate goodwill that he created with his customers and the important aspects of that value that was secured through trademark. And if people copied his code directly, he could sue them for copyright infringement as well. And so again, the important point is to recognize that IP, intellectual property, is not the same thing as patents. Is just one part of a whole buffet of different types of legal protections for different types of innovative and creative labors. And you have appropriate protections in the relevant context. And this is true of property rights generally. We have property rights in water, and property rights in air, and property rights in personal property, chattels like your phone or your car or your scooter, property rights in land, right? And all of these property rights are different. They're very different from each other. They have different types of protections, different types of limitations and liabilities. In fact, this is why I spent a whole 4 months teaching just property in my law school. So the important way to recognize is that even the variation of intellectual property protections that we classify in this broader category is just still part and parcel of the variation of property right protections more generally across the board. In fact, there are some very interesting correlations I've written on this between kind of the types of legal protections in water, which is called riparian rights, and patent rights, because water rights are also non-rivalrous and in some respects non-exhaustive. You know, a stream is flowing, you can take buckets out of it, and it doesn't make it less of a stream for other people to take buckets out of it or to use it. And multiple people can use it at the same time without being in conflict with each other. And interestingly enough, the type of legal rights that you get in water are similar to the types of legal rights you have in patents as well, because there are different types of values that people are creating in these different types of resources.
Okay, great. Maybe we can get in one more. Well, we won't call them patent trolls. On non-practicing entities, Patrick Holmes points out that an issue with them is that they often approach companies and extract nuisance value of a patent suit for patent reads that are a stretch.
Yeah.
Since patent suits are very expensive, the nuisance value they can extract is sometimes large, and this is a drag on the industry. What do we do about that?
So the last claim is a non sequitur from the prior premises. So yes, there are some bad actors in the patent. I don't deny that. One company, MPHA, that was the company that was sending all the patent demand letters to the mom and pop coffee shop saying, you're violating our patent on a Wi-Fi patent. And by the way, they got sanctioned for deceptive trade practices because they were lying in their demand letters because their patent was no longer valid. They weren't providing the necessary information to even find the patent in their demand letter. And it was, I mean, this was fraudulent activity. And this is why we have fraud laws. This is why we have laws, legitimate laws, not even, I mean, a lot of times this is channeled through antitrust, unfortunately, but, you know, there's common law protections against fraud and what the common law is called unfair competition, deceptive competition practices and things of the sort. There's rules in the patent system to address this as well, that prevent people from engaging in improper use of invalid or unnecessary or bad patents. And you can invalidate patents. That's why all defendants have the ability to do so. Or you can do your own investigation, find the patent's invalid, and you're like, well, I'm just going to ignore this. And they can sue me if they want because they know they're going to lose. And that happens a lot too. Now, this happens in the patent system, just like it happens that, you know, the old men chase children off of their property with lead pipes. That happens too. I have cases that I teach my children about that, or my students about that, my professional children. But we don't then say, oh, old men with pipes are a drag on our economy because they're abusing their property rights. They might be, if we can, maybe we need to develop new doctrines and new issues to address that. But this is what I'm trying to say is that we have a lot of claims and assertions by this, but we don't have actual evidence. There's no agreed upon objective foundation. There's a lot that establishes that actually there is a systemic problem with patent trolls. That's never been established. What you have are anecdotes, and anecdotes is a type of evidence, but you can't infer from a couple stories of bad actors systemic problems. Then you can say this is, quote, a drag on innovation, because this is no different, because there are bad lawsuits in every area of law. There are hundreds of thousands of lawsuits over land every year in this country. And a lot of them are ridiculous, right? They involve silly disputes between neighbors. Now, do we then say, ooh, this is a drag on our economy and we need to rethink about whether we protect property rights and land and how people can sue, and we need to make it harder for people to sue for trespass or nuisance and things like that? Well, we haven't done that because no one's ever shown that actually there is a systemic problem with people abusing their property rights and land. And we should apply the same empirical standards, database standards, to our assessments of the patent system. And our default premise should always be, remember, the patent system is a valid good system. And we need to be careful because there's a lot of rhetoric and there's a lot of arguments made by people who are inherently patent skeptics. They were patent skeptics before the patent troll narrative came around. And they just said, ooh, here's a really cool narrative I can use to continue to push my general attacks on the patent system as such. And we're seeing this today with the COVID-19 pandemic. Starting in February, there were activists, and academics like Mark Lemley and others who are saying, oh, we have to restrict patent rights here because patents are a blockade to medical treatments being developed. So, we have to come up with an open patent pledge, and we have to have the government exercise what's called a marching power to actually confiscate patents. People were saying this in February before there were even any treatments, no treatments at all yet, right? And it's because they're following the famous maxim by God, I'm sorry, I'm blanking on his name. Chief of Staff of Obama back in 2009 during the Great Recession. He said, never let a crisis go to waste, right? And if there's not a crisis, create a crisis, right? I mean, this is how a lot of emergencies and crises are a lot of ways in which bad legislation and bad laws are passed to infringe upon our rights and to restrict the ability of people to exercise their rights of life, liberty, and property including intellectual property. And we need to be sensitive to that context.
All right, great. We really do need to wrap up. Adam, if people want to follow you and your work or learn more about you, where, do you want to give your website or Twitter or whatever your preferred?
So they certainly follow me on Twitter. I have Adam Mossoff. In fact, I do on this date in innovation history because people are oblivious to actually how much patents underlie everything in our society, from our coffee machines to our screwdrivers to our automobiles. They think it's just they think it's just drugs and smartphones. In fact, today, for instance, is the anniversary in 1902 of John Browning getting his patent on his very famous semi-automatic pistol, the Browning 1911 or Colt 1911 45 caliber pistol. And today is also the anniversary of the patenting of the modern submarine by John Holland, which he built for the Navy. And I think it was 1910 that he got it, I believe. So I post this on my Twitter account, and also I don't have a website per se. I sometimes share things on LinkedIn, but I share a lot of my writings and activities and other types of stuff going on in the patents and innovation space on Twitter. And you can also go to ssrn.com. And it's linked to in the bio for this for our event here, where I post all my articles. I'm a professor, so I want my articles to be read. So I post all my articles, and I also post amicus briefs and letters to Congress and my congressional testimony and other things that I've done as well there.
All right, great. If you want to follow me, I'm on Twitter at Jason Crawford, and my website is rootsofprogress.org. If you want to learn more about progress studies for young scholars, our high school program, go to progressstudies.school. And Adam, thank you so much for taking the time today. This is a great conversation.
Thank you. And I really quickly want to say too, you always feel that you email me. I know that's kind of old school these days, emailing, but feel free to email me. I'm always happy to point you to resources or answer a quick question if anyone has one. Love it.
Great. Very generous. Thanks so much, Adam. Have a great day, everybody. Thanks for joining us.
A lot of fun.
Take care.